Perhaps absolutely nothing can drive a person crazier, quicker than a non-compete agreement. How can slavery exist in the year 2017? Well, you got to kind of look at things a little conceptually. Obviously, if you have a rock and roll band and you bring in a lead singer, and that lead singer is unknown, and you train that lead singer and he learns all of your music and all of your songs, and he learns all the moves on stage that you teach him, and you know that this person's going to become wildly popular, and over time people are going to associate that guy with your band. And if that guy goes off and starts his own thing, all of your fans are going to go with that guy because it's his voice they hear on the radio. And so when you're the face of a franchise, obviously the company has a legitimate interest in making sure that if you leave the band, you can't compete with them for a while so they can get a new face of the franchise. So not all non-competes are evil, but a lot of them are, especially when somebody comes to me and they say, I'm just a hairstylist. I make a few $100s a week, and I was fully trained, and I came to work for this person, and I didn't really learn any trade secrets. And I have some clients, but I'm not going to solicit them when I leave. And I just want to go work. I just want to go cut hair. And this stupid agreement says I can't cut hair for a 100-mile radius. That means I can't cut hair in Salt Lake, Provo, Ogden. This is stupid. Yeah, it is absolutely stupid. But a lot of people will call me on the phone and they'll say, isn't it true that this non-compete isn't worth the paper it's printed on? And you got to be really careful with that. And I have to tell people, you need to come to my office and we need to review this very carefully. And we need to review what your job duties were, what your pay was, what your job duties are now, and so forth. There's a lot that goes into this. So here's the new law, and this is under Title 34, Chapter 51, Part 2, Section 201, in case you wanted to know, of the Utah Code. And let's just take a look at the most important language. Even though it says post-employment restrictive covenant, that just means a non-compete agreement right here. This just means non-compete agreement, okay? And this says that any non-compete agreement entered into on or after May 10th, 2016 between an employer and an employee can only be for 1 year, okay? It cannot be more than a year or it's void. Now, there are some things to keep in mind here, and that is that if when you decide to move on, the boss comes to you and says, hey, let me give you a severance package of thousands of dollars, but by giving you that, you're going to agree not to compete against me for a certain amount of time. Those are more complicated, and if you're dealing with a severance agreement, make sure you go and talk to an attorney. All right, now, contracts that were entered into before this date are a different animal. So if you entered into your non-compete before May 10th, 2016, okay, that's a different animal. You need to talk to an attorney about that. All right, but keep in mind that all of these non-competes have to be supported by some sort of consideration, and usually giving you a job or continued employment can be sufficient, and they have to be negotiated in good faith. So if your boss gets you to sign a non-compete agreement and then he fires you the next day and says, you're stuck, well, that's not good faith. You can't be a rascal when you enter into a contract in Utah. Every contract in Utah is subject to the covenant of good faith and fair dealing, okay? Like, for example, you can't sell somebody your chocolate store, and then after they buy it, you build a brand new one right across the street, and all your customers come to you instead of them, and you say to the person that bought your chocolate store, sucker. So you can't do things like that. It also has to be necessary to protect the goodwill of the business. So if you're involved in a common calling and you're cutting hair for a living, or you're selling cars, or you're a run-of-the-mill plumber or electrician or something, and people don't really associate the franchise with you. And if you leave, it's not like a boatload of people are gonna look you up and leave the company to do business with you and only you. They will probably continue to do business with the company instead of following you. And if you've got a customer list, you can't solicit customers from that. And of course, you can't disclose trade secrets. So if you work for Coca-Cola, you can't go to work for some new startup company and give them the secret to, the recipe to Coca-Cola. And if an employer tries to enforce a non-compete agreement that's bad, the employer can get stuck with attorney's fees, which is a great thing. The number one thing that you want to look at when it comes to a non-compete agreement is this. Since you signed that non-compete agreement, have your job duties changed? Has your rate of pay changed? I would argue that if your job duties changed materially and significantly, or your rate of pay changed materially and significantly, your boss should have had you sign a new non-compete agreement. And there's a lot of law coming out of the Northeast in this country on this particular subject. Also, if the boss wants to come in and shut you down from working for somebody and suing your new employer for aiding and abetting, your boss is going to have to prove that he has clean hands. One thing that we don't want in the United States of America is what's called a restraint on trade. And so the court isn't going to uphold a non-compete agreement just because your boss doesn't want you competing with him. It's got to be a little bit more than that. So here's what it says. There was a person by the name of Finley who was involved in litigation. And the Finley case said, wait a minute, what do we do with people who were just car salesmen or hair cutters or, a waiter? Isn't this a common calling? And Utah kind of leads the nation in this case law, in my opinion. But look at what the court said. The court said covenants not to compete are enforceable if carefully drawn to protect only the legitimate interest of the employer. And just to prevent competition is not a legitimate interest of the employer. The reasonableness of the non-compete agreement depends upon several factors, including the geographical extent, the length of the non-compete agreement, and right here, the nature of the employee's duties. So if you're just, like I said, cutting hair for somebody and they have you sign this non-compete agreement, the judge would say to the employer, wait a minute, this person was cutting hair. Did they learn any trade secrets? Did you pay for any specialized training? No, they went to beauty school and came to me already trained. Okay, what trade secrets did they learn? And then there's this goodwill of the business. This is a big deal because if you're the face of the business and you leave, everybody will go with you. So if you're a rock and roll band and you tell the lead singer, okay, we're going to bring you on. Nobody knows who you are. But after a year or two, everybody's going to, know you're the lead singer of the band. And if you leave our band, people are going to associate our band with your face and your voice. And all of our fans are going to go with you. So that lead singer is going to have, being the face of the franchise, you're going to want that. The owner's going to want to get that person under a non-compete agreement. Or if there's some sort of extraordinary investment in the employee or a lot of training or education. So if those things are going on, the court's more likely to enforce it. But notice what it says here. It says, in a general sense, the law balances the nature of the interest of the one seeking to enforce the non-compete agreement, the employer, whether by injunction, in other words, an injunction means you're shutting the employee down from competing against you, and you can also get a court order or an injunction shutting down his new employer from hiring or working with that former employee. So it says the court has to take into consideration the hardship imposed on the employee. Now, I will tell you, normally speaking, non-compete agreements in Utah are enforced. But I will also tell you that over the last several years, we have been able to get our clients out of many non-compete agreements. So anyway, in this particular case, and you can read it, it says, in this case, the non-compete agreement served no purpose other than restricting an employee from competing with a former employer. So I love this case, and this case has just some great language in it. It quotes from a New York case that says, it is clear the non-compete agreement's broad speaking language was unrestrained by any limitations key to the uniqueness of the employee services. In other words, the employee wasn't doing anything special. He was selling cars. He was cutting hair. This kind of thing. Trade secrets, confidentiality, or even competitive unfairness. It does no more. This is what the court said in New York, that the particular agreement at issue in New York did no more than baldly restrain competition. And it says, this it may not do. So you can't have a non-compete agreement, again, just to restrain competition. And then a lot of times the boss will say, well, yeah, but he learned a lot while he was working for us. And this is what the Utah Supreme Court quoted from a Texas case. It doesn't matter when they say it is of no moment. That means it doesn't matter. It doesn't matter the defendant may have been especially proficient in his work. So I may come to work for a beauty salon, and I'm fantastic at what I do. And customers love me because I'm so good at cutting hair. It says right here, it says it doesn't matter if the defendant, the employee being sued, was super good at his job. And it says here, general knowledge or expertise required through employment in a common calling cannot be appropriated as a trade secret. Okay, so someone comes to work for a law firm, and they learn how to file divorces and bankruptcies, and they watch the attorneys write contracts. They learn a whole ton of stuff about the law. It doesn't matter. Just because you acquire a lot of general knowledge or expertise right here, just because you get a lot of general knowledge and expertise through your employment in a common calling, that still is not, some sort of stolen trade secret by the employee when he leaves. Now, this is important. The efficiency and skills which an employee develops through his work belong to him, not to his former employer. This is more from the Utah judiciary, and it makes it very clear that if you're going to enforce a non-compete agreement, you have to show that the services rendered by the employee were special, unique, or extraordinary. So anyway, there are a lot of factors. Call an attorney. We'd love you to call us, 801-641-3397. I am Greg Smith, and you have a wonderful day.